Mr. Harrington.
May it please the Court, William Harrington for the defendant. The principal argument I want to put forth today is that the jury instructions given on the charge of rape, and in particular the issue of capacity of the complainant and the impact in the defendant's knowledge of any incapacity and the impact of his intoxication should have on that analysis. I am the successor counsel, and there are two other arguments that I don't want to go forward with respect to the issue of sufficiency of evidence on penetration and the Sixth Amendment argument. I withdraw those arguments. But going back to the principal argument, here...
You mean you don't want to make oral argument, or you're waiving those arguments altogether?
I'm waiving those two, and that just
Together.
for... I'm sorry?
Altogether, is that right?
Yes, just sufficiency of penetration. I concede that there was sufficient evidence on that issue. And with respect to the Sixth Amendment, I concede that trial counsel basically agreed before trial for that expert to testify as to the other expert's findings. So I'm not going, I withdraw those two arguments. But with respect to the principal argument, with respect to the jury instructions, here, this is a case where the complainant was a 16-year-old young woman who the evidence would suggest had alcohol. It's very unclear how much she had, but she and the defendant shared at least a 750-milliliter bottle of vodka. Then he went out and bought some more. It's unclear. There's no evidence actually that she drank any more of that. But certainly there's evidence that both of them had been drinking and suggests that both had been drinking excessively.
Was there any evidence other than the fact that she was totally unconscious during all of this when this rape occurred, alleged rape occurred?
Well, with respect to her testimony, I think a jury could infer, at least for this argument, that she was unconscious from drinking. But I think they also could infer that she had been drinking, she wasn't an experienced drinker, and that just didn't remember what happened. And I don't think that if the jury convicts that it's inescapable that they concluded that she was passed out from intoxication. I think that's very important with respect to the defendant's knowledge of any incapacity, because I think a jury could fairly look at the evidence and say she must have been conscious. Maybe she was under the influence of alcohol, maybe she doesn't remember it, because there's a few things. For one, if you look at her testimony, if you credit her testimony after she had her last drink, she refused to have any more drinks. She refused to go to a park with the defendant when they're driving home from the liquor store. It's clearly at that point in time she is able to consent and not consent, and according to her, she is no member of drinking. I think the jury could infer that she must have been drinking after that and simply forgot about it. Secondly, regardless of whether you can make that inference, there's evidence that she pointed, there's an exhibit, and it's attached to the Commonwealth's brief in the record appendix of the layout of the apartment, and she writes where she woke up. There is some suggestion that she woke up, she went off the side of the bed. But it's clear from her testimony in this diagram that when she remembered, when she came to, she was on the floor at the foot of the bed. Her testimony was that she went to sleep, and then the next thing she remembers, she's at the foot of the bed. Jury, perhaps.
Excuse me, I thought she was between the bed and the wall.
No, there was some testimony that she had told the police that, and but she was clear in her testimony at trial that she on this diagram, Exhibit 1, she writes where she was, and it was at the foot of the bed. And there is some testimony, it's very unclear, that she was basically saying that that's what she meant. She was at the foot of the bed, and that was near the wall, so that's what she meant. But if you look at that diagram, how did she move from the sleeping position in the bed to the foot of the bed? Either maybe she was passing the defendant, picked her up and moved her over there. Maybe she got up.
But she clearly vomited, correct?
Yes, and that's...
And did she testify that she has it? I mean, so she was asleep. I mean, I guess doesn't that also go to the passing out? There's no testimony, is there, that she remembers vomiting?
She's no testimony. Actually, I think the jury could infer that she vomited. There's no testimony as to who vomited, but I think the obvious inference was that she vomited. But with respect to that issue, certainly that's issue of intoxication, perhaps extreme intoxication, but it's also issue of someone perhaps being conscious. Typically people, when they vomit, are conscious. And secondly, the vomit was found on the bed, on the floor, in her hair, on her shirt, indicating that maybe she was moving when she was vomiting, indicating that she was conscious.
Well, I would agree with you. It's a fair inference she was moving. I don't know about the consciousness, though.
Well, I understand that, but with respect to if she is intoxicated, and to the extent that she doesn't remember, she certainly could still be able to consent and to be conscious with respect to the defendant's perspective. Now, I think that's a fair experience that people sometimes do things when they're intoxicated, don't remember it, but if someone were reviewing the night before, they wouldn't think the person is incapable of consenting. I think there's a difference. That the fact is, the reasonable inference from this evidence is either she's passed out or she just doesn't remember what happened.
Do you think that it's part of the reasonable inferences about what he could perceive, that he was essentially plying her with liquor? I mean, that's the testimony from the Commonwealth's point of view, that, you know, she didn't want it, then she took some, a small amount, then he kept pouring the vodka, a lot of vodka for an inexperienced drinker.
There's certainly the evidence, even if there was consent, it certainly doesn't paint my client in the best light, and most people regard it as very shameful behavior. But with respect to
really just going
to plying,
yeah.
I think the evidence was that perhaps he was inducing her to drink, but the only evidence with respect to her ever saying, I don't want to drink, he didn't force her to drink. He was trying to persuade her to drink, but then he left the room. That's the only evidence. So there's certainly no testimony of forcing her to drink. There's no charge in the
throwing it down her throat. I mean, putting it in a glass so that she doesn't even know how much she's drinking with orange juice. You know,
there is testimony that her second drink, her testimony that he poured, was more than her first one that she poured.
Could we get to the instruction itself?
Yes.
What, other than what Judge Whitehead said, could that language about reasonable person mean? I mean, you really think that it means a reasonable intoxicated person? I mean,
I don't think it's a reasonable intoxicated person, but I do think the jury should say the defendant, that defendant at that point in time, not the defendant a day earlier when he's sober, you know, whether he should have gotten drunk or not, but that defendant at that point in time, I think that's what it means. It's not a reasonable intoxicated defendant or a reasonable intoxicated person, but it's whether he knew or should have known. In determining whether he should have known, I think the jury should have been either Judge Whitehead should have just left it alone and kept the Blatch instruction without elaborating on the impact of intoxication. But he did that, and I think with respect to the proper instruction, it should be the defendant at that point in time. Should he have known? In that analysis, you should consider his state of mind.
Okay, but isn't that a subjective standard being overlaid with an objective standard? I mean, it's a reasonable person. It's not. He did give the alternative of an object of a subjective standard, and as to that, he did speak that you may consider intoxication. So, but now we move to the objective, and why is it what the defendant himself thought?
Well, because I think Blatch is simply a re-articulation of Burke. They make clear, the SJC makes clear that they're not changing the law; they're just reformulating it or restating it in more modern language. So Burke basically says it's new. I don't have the exact language, but basically suggesting subjective. In Blatch, this court basically in a footnote talks about, well, it suggests it's subjective, but it's a little broader than that. I don't think it's purely subjective. I would make an analogy to the instruction recently by this court in De Padova, which deals with criminal responsibility and the impact of alcohol, and if someone has a mental condition and they are intoxicated, the issue of whether they should have known that was going to exacerbate. In that, obviously, intoxication doesn't really matter in that situation because you're dealing with the defendant prior to his intoxication. But it does make clear that you look at the defendant as he is at that time. And it says, in deciding what the defendant had reason to know about the consequences of his consumption of drugs or alcohol, you should consider the question solely from the defendant's point of view, including his mental capacity and his past experience with drugs or alcohol. That is, and it's not really on point because it doesn't deal with intoxication, but that's an objective standard, but it's an objective standard that looks at the defendant, his capacity, his mental capacity. A defendant who may be blind, you would consider that. A defendant who has some mental insufficiency, you consider that. You look at the defendant in the condition he was at the time that he should have known. So there is an objective component.
But his condition at that time was intoxicated, and you say he shouldn't have said the average intoxicated person, or this person. I'm trying to figure out what the reasonable person would be under your. I mean, in the facts of this case. And Blash was a police officer. There was no issue of intoxication on the part of the defendant.
Well, Blash doesn't say a reasonable person. It just says should have known. I'm asking the court in interpreting what should have known. It's not a reasonable person. Is that defendant at that point in time should he have known? And in taking that into consideration, you should look at his mental capacity and his mental state at that time. Certainly, and just. Going back to Burke, that is essentially subjective, and I think given that Blatch really was just re-articulating that, I'm not asking for a purely subjective, but it's something that where the jury looks at it, says he either knew or, of course, he should have known. People who are intoxicated typically know what's going on around them. It's not something that takes reason. Here, I would submit that if the only evidence was that the complainant was passed out from alcohol during the alleged assault, then whether he's intoxicated or not, he could infer that she has incapacity. But my point is that the evidence could have been looked at different ways, in that the jury could very easily infer that the complainant must not have only had more than 2 drinks, must have had much more than that, and simply does not remember what happened. And in looking at that, concluded that she was, in looking at that, the jury should have really been instructed. You have to look at it from the defendant and the state of mind or condition he was in at the time. Judge White had specifically instructed the jury, don't even ignore that. I mean, his instruction raised the possibility that there could be mutual rape where 2 people who are extremely intoxicated have sexual relations, and the next morning say, gee, I wouldn't have consented to that. That was terrible. And looking at the situation from that perspective, whether the one defendant should have looked at the person and whether a reasonable, sober defendant would have realized the other person was very drunk, that's a different situation. And that instruction really raises that possibility where the defendant is held to a standard that
So let me see if I understand. If the evidence was that the complainant in this case was completely incapacitated, unconscious, then it really wouldn't matter the state of intoxication of the defendant. Is that right?
Well,
where there's a possibility that she may have been incapacitated but wasn't unconscious, then the question is whether the defendant was aware that she was unable to consent, and in assessing whether she was aware, how should we assess the fact that he was intoxicated? Is that the problem?
Yeah.
And we've articulated that knew or should have known, and so the problem is, what does should have known mean in those circumstances? And
here, the judge instructed, obviously, look at a reasonable person who's sober.
Yeah, look at a reasonable person who's sober. That's sort of would be one way of looking at this. That's an objective standard, but you're saying that really makes no sense here.
It doesn't make any sense in that if you looked at Blanche as just a re-articulation of Burke, that it's basically no, and they make clear there's no statement as a reasonable person. And I think it's really you have to look at the state of mind of the defendant at the time. Just jumping to there's some other aspects of the jury instruction which the defendant did not specifically object to, but I think should be in the mix in terms of prejudice. In that here the judge never instructed on the element of force. The instructions in this case really suggested to the jury that she had no capacity to consent. Judge Whitehead talks about 3 elements: intercourse without consent, and the third element, he says, is it must prove that the defendant knew, or an alternative, he reasonably should have known, that the complainant was impaired to the point that she was incapable of giving consent. He does not make clear that and he does state it once, but that the general thrust of his instructions is that he does not make clear that the Commonwealth has to prove this, prove that she was incapable because of extreme intoxication to consent, and then also show this. The emphasis in focusing on the defendant's knowledge, the court suggested that the lack of consent was already established. I see my time is up. Thank you.
Mr. Steinfeld.
Thank you very much. Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. I'd like to begin with Justice Cordy's comments about the state of the evidence regarding the complainant's intoxication. There was no evidence of anything other than she was completely unconscious, in the language of the old cases, wholly insensible, basically in a state of stupefaction, in a stupor as a result of the alcohol that the defendant had provided her. There was
the only evidence. I mean, the defendant didn't testify, did he?
No.
So the only evidence we have is the complainant, who says, or at this point the victim, but who says, "I don't remember," right?
Well, yes, we have her testimony that she went to bed and that she was awake for a few moments. The defendant came in with her glass and sought to try to get her to take more alcohol, and she said no, and then, quote, "The next thing I knew, it was 5 a.m. However, there was no testimony from Sam, who slept very close by in a very small apartment, that she ever got up in the night, that she ever moved, or that she was anything other than asleep all night. Furthermore, the defendant, in his statement to police, though he did not testify at trial, his statement to the police did not mention anything about the victim getting up or moving around or being anything other than unconscious when she went to bed. So I think that this is a case in which the evidence showed overwhelmingly that the victim was wholly insensible. And this is not a case like Blanchet and various others where the complainant is a person who is coming in and out of consciousness, has some memory of some things and and fails to remember other things. She clearly had no memory of anything, but she woke on the floor between the wall and the bed, and there was vomit all over the room, and there was wetness in her privates, and that's all that she knew. I'd also like to stress that the Blanchet formulation, the second prong, is not should have known, but reasonably should have known. So I think there can be no question that that prong deals with the reasonable person, and historically at law, the reasonable person is a person who is not intoxicated.
Now, as to that, why would we not adopt something similar or identical to the third prong of malice, which is a reasonable person, but says in the circumstances known to the defendant?
Sure. Well, this Court did not use that language in Blanchet as it could have if that had been the Court's intent. There is a way to put it, as this Court has when talking about third prong malice, that has both an objective and a subjective prong. And the answer, I think, lies mainly in the fact that rape is and always has been a crime of general intent, whereas murder is almost always a crime of specific intent. So I think that the nature of the crime is so different that it would not make sense to permit a person charged with rape to have this same sort of defense that a person contesting a third prong malice charge would have. I think to do so.
On these facts, though, wouldn't your argument be the same? That if you looked at it that way, in the circumstances known to the defendant, which you would say means she's unconscious,
right,
a reasonable person would know she couldn't consent. I mean, it doesn't come out any differently, does it?
Right. Plus, I think that a reasonable intoxicated person would know that she was unable to consent. So I don't think it much matters in this case because there's no evidence that she was anything other than wholly insensible. And the defendant here was capable of doing a bunch of other things after she had gone to bed. He went upstairs to visit his friend. He came back. He had no problems negotiating a flight of stairs. His son said that when he came to bed, he smelled of alcohol, but he didn't say that it was a lot of alcohol. The defendant had told the police that...
He moved.
Pardon me?
It's strong enough that he moved. The son moved, right?
Yes. Yes, that is certainly true, that he moved to the other bed. But that's not an indication of the extent of intoxication. One can have a single glass of wine, and a 10-year-old child could say, ooh, you stink, and I don't want to sleep in the same bed with you, and move to another bed. So I don't think that's very strong evidence that he was so incapacitated. That's another point I'd like to make. The defendant would have to be so drunk not to recognize that the victim was wholly insensible. That's way beyond the highest finding that the jury could have made here as to how drunk he was. As I said, he didn't stumble, he didn't straggle, he could do things. But for somebody to have sexual intercourse with somebody who is unconscious and then say afterwards, I didn't know that she was unconscious, that's a vast state of intoxication that there's no evidence here that supports that.
Well, the jury had a problem. They were hung up on the question of whether or not he had knowledge that she was incapable of consenting. So they asked a question about that. We're not quite sure how to deal with that issue.
Right, but that was as to the first prong, the new prong. It was completely limited. The jury question was solely, we are having a hard time understanding how to determine whether or not the defendant knew.
Right.
And the judge re-instructed as he had previously
and so
instructed.
they essentially could have said, well, we don't have to decide that because the judge said, would a reasonable, sober person have known? Well, that's an easier question, right? So we might actually assume that that's the basis on which the jury decided, that a reasonable, sober person would have known. And the question is that the standard to use in these circumstances?
Yes, I think it is. And we don't know which prong the jury found. It certainly seems by the nature of the question that they were conscientiously considering both prongs. They didn't say, well, we don't need to consider whether he knew because we can say right away that a reasonable
sober person would have
right,
known.
Right. So clearly they considered both and found on one. The Commonwealth is in the disjunctive. The Commonwealth only had to prove one of them and apparently did. The reasonably should have.
So that instruction is not superfluous. It's right in the bullseye here.
Yes.
It makes a difference.
Well, no.
If that instruction's wrong, it makes a difference. It's not that, well, the jury could never have, I mean, she was obviously unconscious. The jury could never have found it. That anyone wouldn't have known.
Yes, it could have made a difference if they found that the defendant subjectively did not know that she was incapable of consenting. It could have been the difference between a conviction or a verdict of not guilty. But I think that, excuse me, Justice Gantz, no.
No, finish, you finish.
I just was going to say that the purpose of that second prong, the reasonably should have known, I think is made very clear by the back and forth in the Blanchet decision between the majority and Justice Spina's concurrence, joined in by Justice Cowen, where it makes plain that the purpose of that second prong is circumstances in which there's no way that a defendant could know that the victim was incapable of consenting, such as when a victim has a brain injury or suffers from mental retardation, but a person who observed that person, who interacted with that person, would not know or be able to know that that person was incapable of consenting. That prong exists not to save a defendant like this, who gets drunk and then has sex with someone who's wholly insensible, but for somebody who has sex with another person whom he could not possibly know was incapable of consenting. That's just not the case here, because this defendant and virtually anybody else could possibly have known and should and reasonably would have known that a girl who's been plied with liquor by the defendant, as has been pointed out, I think the verb to ply was made for this case. It's exactly what he did from the very beginning. He wanted to go off and drink on the beach with her following the second trip to the liquor store. So it's pretty clear what his intentions were.
Let me ask you this question, and it goes to what you just said a moment ago. What if this defendant was mentally handicapped, had an IQ of 70? Would he be evaluated on the objective prong as a person of average intelligence?
Yes, would a person of average intelligence, sober, should such a person reasonably have known that this person with an IQ of 70 was incapable of consenting? And that's
No. I'm referring to the defendant having an IQ of 70.
I see.
Not the victim. I'm saying imagine we have a defendant who's intellectually handicapped and has an IQ of 70. Would the standard be a person of average intelligence who is sober?
He's capable of forming the general intent to commit the act. So no, I don't think that would save such a person from a.
Because of the nature, unless you change the law of general intent.
That's right. That's what this court would have to do to make that the case.
But the problem, as you know, the problem is if you have if your theory is that the complainant was incapable of consent,
right, and
then essentially the element of force goes away.
Yes, it does.
And the element of force is the reason why we say this is a crime of general intent.
Right.
But if it goes away, all of a sudden you have a crime that really requires specific knowledge.
Well, but not if the or when the victim, as here, is wholly insensible, then that's not the case.
I understand, but this instruction that you're talking about would relate to someone who the jury would have to decide, well, were they too intoxicated to consent or not?
Well, a lack of intelligence on the part of a defendant, short of rendering him incapable to stand trial or to lack criminal responsibility, is not a defense to general intent crimes that I'm aware of. So I don't think that it should be in this case, where the law, as Justice Pina said in concurring in Blanchet, has always been tethered to the law of general intent. I think that if this court were to take the defendant's proposed instruction, that it would tend to untether.
But only in the circumstances where the question is whether the complainant was capable of consent, not whether the complainant consented. Did the complainant consent or not is a different issue than whether she was incapable of consenting due to intoxication or other factors.
Right, but the defendant with a low IQ also has the no prong that the Commonwealth has to surmount to show that this person knew.
I'm sorry, could a defendant with a low IQ present the equivalent of an insanity defense in a case like this?
Well, he could present a lack of criminal responsibility, but then he would have to meet the standard of that test.
That because of his mental condition, he was unable to appreciate the wrongfulness of his conduct. He was unable to appreciate that the victim was not capable of consenting.
Right. Certainly, that defense is available both to general and to specific intent crimes. So certainly, if he could make that showing, then of course he would be found not guilty of rape in those circumstances.
Is this same issue raised by the question of whether a defendant knows that somebody is under 16 or not?
Well, I think this is strict liability. I think is a whole different.
Oh, okay. So
game
it's
than this is. So I don't really see how the analysis for one would extend to the other. That has other factors obviously taken into account. Society's need to protect children that don't come in here because she was 16, almost 17. So certainly an adult, and the age doesn't play into it at all. Unless the members of the court have any further questions, I'd be happy to rest on my brief for the remainder of my argument.
Thank you.
Thank you.